Hello everyone, welcome to the channel OCS by Ranjan. आमर OCS by Ranjan ऐप रे टेस्ट सीरीज स्टार्ट हो सारी आपण मैंने जॉइन करें एवं आप चैट बॉक्स रे डिटेल्स आपण मैंने सार चैट करें किंबा नंबर टी लिखि नियंतु सार को व्हाट्सअप करें 7978405181 टेस्ट सीरीज जॉइन करें जहाद्वारा आपणकर प्रिपारेसन टी बेस्ट रहिबो एवं भलो यूनिवर्सिटी मिल पारे। चलतु आज डिस्कस करिबा CPET LLM क्वेश्चन पेपर 2021। क्वेश्चन नंबर 1, whose lecture were published under the title The Province of Jurisprudence Determined। ठीक आंसर टी हेबो ऑप्शन डी जॉन ऑस्टिन। क्वेश्चन नंबर 2, the Carlyle versus Carbolic smoke ball co-case is related to option B offer to public at large। This is a landmark case in contract law. The Carbolic smoke ball company's advertisement promising a reward to anyone who used their product and still got sick was deemed on an offer to the public at large, not just an invention to treat Mrs. Carlyle's acceptance by performance using the ball and still getting sick created a binding contract। Question number 3, adherence to precedent is called to doctrine of option A stare decisis is Latin for to stand by things decided. It is the doctrine that courts should follow precedent set by previous decision when deciding similar cases. This promotes consistency and predictability in the law। Question number 4, which of the following can be included in right to life under Article 21 of the Indian Constitution? ठीक आंसर टी हेबो ऑप्शन ए। Article 21 has been extensively interpreted by the Supreme Court to include various rights essential for a meaningful life. The listed options all fall within the board interpretation। Question number 5, who is called as Darwinian before Darwin and sociologist before sociologist? ठीक आंसर टी हेबो ऑप्शन ए। Question number 6, the instrument of instructions contained in the Government of India Act 1935 has been incorporated in the Constitution of India in the year 1950 as fundamental rights, directive principles of state policy, extent of exclusive power of state, conduct business of Government of India। यार ठीक आंसर टी हेबो ऑप्शन बी। The directive principles of state policy part 4 of Indian Constitution are derived from the instrument of instructions in the Government of India Act 1935। They lay out board guidelines for the state to follow in promoting social and economic justice। Question number 7, in which landmark case the Supreme Court held that the second marriage of Hindu man is invalid even if he converts to Islam before marriage? यार ठीक आंसर हबो ऑप्शन बी। The Sarla Mudgal case dealt with the issue of Hindu man converting to Islam to marry again without divorcing their first wife. The Supreme Court held that such conversion solely for the purpose of marriage are invalid and would not dissolve the first marriage. Question number 8. Article 16(4)(a), which gives power to the state to provide reservation of SC/ST in matter of promotion, was added by the option गुड़ाक देइछि 75th amendment to the Constitution of India, 76th, 77th and 78th amendment to the Constitution of India. यार ठीक आंसर है ऑप्शन सी. The 77th amendment enacted in 1995 added clause 4A to Article 16. This amendment clarified that the state can make provision for reservation in matters of promotion for scheduled caste and scheduled tribes. Question number 9. A man shall be guilty of the offence of sexual harassment under section 354A of Indian Penal Code 1860 if he commits यार ठीक आंसर टी हेबो ऑप्शन डी. Question number 10. A company has to submit a statement of affairs to the official liquidator within dash days of the appointment of the official liquidator. ऑप्शन गुड़ाक देइछि 10, 14, 21 and 30. ठीक आंसर हेबो ऑप्शन सी 21. According to the Companies Act, a company is required to submit a statement of affairs to the official liquidator within 21 days of liquidator's appointment. This statement details the company's assessed liabilities, the financial position. Question number 11. Dash define the jurisprudence as the formal signs of positive law. यार ठीक आंसर टी हेबो ऑप्शन ए. Thomas Erskine Holland is a legal positivist, defined jurisprudence as the formal signs of positive law. He focused on the structure and form of law rather than its ethical content. Question number 12. Why an invention should be patented? यार ठीक आंसर टी हेबो all these three are correct. Question number 13. The Supreme Court of India formulated the doctrine of eclipse in option C. Question number 14. Which of the following section of IPC deals with the criminal breach of trust? ऑप्शन गुड़ाक देइछि सेक्शन 407 of IPC, सेक्शन 406, सेक्शन 408 एंड सेक्शन 405 of IPC. यार ठीक आंसर टी हेबो ऑप्शन डी. Section 405 of the Indian Penal Code IPC defines the offence of criminal breach of trust. It involves the misappropriation of conversion of property of a person who has been entrusted with it or has dominion over it. Question number 15. Active concealment of fact is associated with which one of the following? यार ठीक आंसर टी हेबो ऑप्शन सी fraud. Active concealment of fact where someone deliberately hides or suppresses information with the intention to devise is a key element of fraud. It goes beyond more silence or non-disclosure and involves actively misleading the other party. Question number 16. The Supreme Court held in which of the following cases that preamble is not a part of the Constitution of India? यार ठीक आंसर टी है ऑप्शन डी. In the Beruveri Union case, the Supreme Court initially held that the preamble is not a part of the Constitution. However, this view was later overturned in the Kesavananda Bharati case, where the court held that the preamble is a part of the Constitution and can be amended, though the basic structure can't be altered. Question number 17. X cut down a tree on Y's land with the intention of dishonestly taking the tree out of Y's possession without Y's consent. In this case, X commits. ठीक आंसर टी है ऑप्शन डी. Theft is defined as dishonest taking of movable property out of the possession of another person without their consent. In this scenario, as soon as X severs the tree from the ground with the dishonest intention of taking it away without Y's consent, the offense of theft is complete. Question number 18. Consider the following statement. The object of legislation is to apply the law. Legislation has both creative and abrogative powers. Custom is generally based on the will of the people. Choose the correct answer. यार ठीक आंसर टी है ऑप्शन ए. Question number 19. In which case the constitutional validity of the Muslim Women Protection of Rights and Divorce Act 1986 was upheld? यार ठीक आंसर टी है ऑप्शन सी. The Daniel Latifi case upheld the constitutional validity of the Muslim Women Protection of Rights on the Divorce Act 1986. The court interpreted the act in a way that ensured Muslim women were entitled to the reasonable and fair maintenance beyond the iddat period. Question number 20. A divorce by khula is both A and C. Khula is a form of divorce initiated by the wife in which she gives off her dower or other property to her husband in exchange for her release from the marriage tie. It is a divorce with the consent and the instance of the wife, and it can involve agreed upon consideration. Question number 21. Who introduced the concept of pure theory of law? यार ठीक आंसर टी है ऑप्शन डी. Question number 22. Mitaksara Kafarsenary consists of a option B. Father plus 3 lineal male sources or descendants. Question number 23. The appropriate writ issued by the Supreme Court to quash the appointment of a person to the public office is option D. Question number 24. The concept of antecedent debt is the first of all well described in case of option C. Question number 25. According to the Hindu Marriage Act 1955, the definition of Sapinda relationship is under section 2, 3, 4 and 5. ठीक आंसर टी हेबो section 3. Section 3 of the Hindu Marriage Act 1955 defines Sapinda relationship, which is a crucial in determining permissible marriage within the Hindu community to avoid marriages between close relatives. Question number 26. The case of Pakala Narayan Swamy versus Emperor pertains to option B. Dying declaration. It is a landmark case considering the admissibility of dying declarations as evidence. It deals with the legal principles surrounding statements made by a person who is aware of their impending death. Question number 27. The admissibility of dying declaration is based on which maxim? यार ठीक आंसर टी हेबो ऑप्शन सी. Question number 28. Which of the following is true concerning retracted confession? यार ठीक आंसर टी हेबो ऑप्शन डी. Retracted confession must be looked up upon with leisure concern. Question number 29. Which of the following section of the Indian Evidence Act 1872 deals with the public documents? ठीक आंसर टी हेबो ऑप्शन ए. Section 74 of the Indian Evidence Act 1872 defines what constitutes public documents which are accessible for public inspection and often have evidentiary value. Question number 30. The law of evidence is option B. Lex fori. It is a Latin term of meaning the law of the forum. In the context of evidence, it means that the law of evidence applicable in a particular case in the law of jurisdiction where the trial of being held, not necessarily the law where the cause of the action arose. Question number 31. What is the corporate personality? ठीक आंसर टी हेबो ऑप्शन सी. Corporate personality means that the company as an entity is regarded by the law as a person. Question number 32. Criminal conspiracy has been defined as an agreement between two or more persons to do an illegal act or an act which is not illegal by illegal means under section 120B of IPC, 120A of IPC, 120 of IPC, 121A of IPC. यार ठीक आंसर टी हेबो ऑप्शन बी. Section 120A of IPC. It defines criminal conspiracy as an agreement between two or more persons to commit an illegal act or to commit a legal act through illegal means. Question number 33. Zahira Sheikh was prime witness in option B. Zahira Sheikh was a key witness in the Best Bakery case high profile case related to the 2002 Gujarat riots in India. Question number 34. Under the provision of the Indian Evidence Act 1872, which of the following presumptions can be made with regards to telegraphic message? ठीक आंसर टी हेबो ऑप्शन ए. The Indian Evidence Act 1872 primarily presumes that a telegraphic message sent from a telegraph office to the intended receipt was sent by the person purporting to send it. There is no automatic presumptions about the accuracy or truthfulness of messages content. Question number 35. Can a husband be held vicariously liable for the tort of his wife in India? यार ठीक आंसर टी हेबो ऑप्शन सी. In India, a husband is generally not vicariously liable for the torts, civil wrongs committed by his wife. Married women are considered separate legal entities and are responsible for their own actions. Question number 36. A contract by which one party promises the other party to save from loss which may be caused either by the conduct of promisor or by the conduct of the other person is called as option D. A contract of indemnity is contract where one party promises the compensate the other party for any loss or damage suffered by indemnity due to the actions of the identifier or a third party. Question number 37. Every person has a right to defend his own body. यार ठीक आंसर टी हेबो ऑप्शन सी. And the body of any person against any offence affecting the human body. Question number 38. A dash is a contract to do or not to do something if some event collateral to such contract does or does not happen. यार ठीक आंसर टी हेबो ऑप्शन ए. A contingent contract is a correct contract where the performance of obligations depend on the happening or non-happening of an uncertain future event which is collateral to the contract. Question number 39. A threatens to kill B if B does not enters into contact with A or B enters in the contact with A. Here the consent of B is obtained by option A. Coercion involves using threats or force to compel someone to something against their will. In this scenario, A's threat of killing B amounts of coercion fitting B's consent of the contract. Question number 40. Quantum merit means ठीक आंसर टी हेबो ऑप्शन बी. as much as is earned. Quantum merit is a legal doctrine that allows a party to recover the reasonable value of services rendered or work performed when there is no express contract or when the contract has been breached It essentially means as much as is deserved or as much as is earned. Question number 41. In the event of breach of contract, which is the following is correct in relation to remoteness of damage? यार ठीक आंसर टी हेबो ऑप्शन डी. All statements are correct regarding the remoteness of damage. Question number 42. The principle of the thinking speaks for itself is expressed by the maxim option B. Res ipsa liquiter is a Latin maxim that translates to the thing that speaks for itself. It applies in negligence cases where the circumstances of the accident imply negligence even without direct evidence of the defendant's fault. Question number 43. In an action for the tort of negligence, what is not required to be proved by the plaintiff is that option D. To establish negligence, a plaintiff must prove a duty of care owned by the defendant, a breach of that duty, caution that the breach caused the plaintiff's injury and damages. Question number 44. No fault liability means option C. No fault liability, also known as strict liability or absolute liability, imposes liability for damages even if the defendant was not negligent or at fault. This is often applied in cases involving inherently dangerous activities of or products. Question number 45. Dishonestly has been defined as doing anything with intention to cause wrongfully gain to the person or wrongfully loss to another under section 21 of IPC, 23, 24 and 25. यार ठीक आंसर टी हेबो ऑप्शन सी सेक्शन 24 of IPC. Section 24 of the Indian Penal Code IPC defines dishonestly are doing anything with the intention to the cause wrongful gain to the one person or wrongfully loss to another. This intention is a key element in many offences involving dishonesty. Question number 46. Tortious liability arises from breach of duty primarily fixed by law. This duty is towards persons generally and its breach is redressable by an action for unliquidated damages. This definition is given by option A. Winfield. Question number 47. The law of torts is founded and structured on morality that no one has right to injure or harm another intentionally or even innocently. This has been observed in option A. While the principle of not harming others is general moral and legal principle, the specific case mentioned Jayalakshmi Salt Works highlights the connection between tort law and moral obligation to avoid causing harm. Question number 48. appointment under section 36 of the Transfer of Property Act 1882 means ठीक आंसर हेब ऑप्शन सी apportionment refers to the division of rights and liabilities in the proportion to the respective shares or interest of the parties involved in the context of section 36 of the Transfer of Property Act. It typically relates to the division of rent or other income from property based on the duration of possession or ownership. Question number 49. Who has said that an offer need not be made to an assigned person but no contract can arise until it has been accepted by an ascertained person? यार ठीक आंसर हेब ऑप्शन सी ऑप्शन बी. Question number 50. The foundation of doctrine of election under the Transfer of Property Act 1882 is that a person taking the benefit of an instrument must bear the burden. Option B, must bear the burden. The doctrine of election states that if a person is given a benefit under a transaction, they must also accept the associated burden. They cannot accept the benefit while rejecting the burden. Question number 51. The provision of contingent interest is provided in section 20 of the Transfer Property Act 1882, 21 Act 1882, 22 section 23 of the Transfer of Property Act 1882. यार ठीक आंसर है ऑप्शन बी सेक्शन 21 ऑफ द ऑप्शन बी सेक्शन 21 of the Transfer of Property Act deals with contingent interest, which are interest that depends on the happening of uncertain future event. Question number 52. Under the Transfer of Property Act 1882, attached to earth means option D. All these are correct. Question number 53. According to which school the purpose of jurisprudence is to analyze the digest of law of the land as it exists today? Option A. Question number 54. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more person living at the date of such transfer. These provisions came under ठीक आंसर टी है ऑप्शन बी. Question number 55. Which of the following propositions for distinguishing between lease and a license were made by Justice J. Subbarao in Associated Hotels of India versus R.N. Kapoor? ठीक आंसर टी है ऑप्शन डी. Question number 56. In which judicial decision it has been held that it is not necessary that alleged infringement should be an extract or verbatim copy of the original, but its resemblance with the original in a large measure is sufficient to indicate that it is a copy? यार ठीक आंसर टी है ऑप्शन सी. This principle crucial in copyright infringement cases emphasizes that substantial. Similarly, not necessarily exact copying is enough to establish infringement. The R.G. Anand case is significant precedent in this regard. Question number 57. What is meant by the term actionable per se? ठीक आंसर हेब ऑप्शन ए actionable without proof of damage. Question number 58. The section 82 of IPC provides that nothing is an offence which is done by a child under 6 years age, 7 years age, 9 years age and 10 years age. ठीक आंसर हेब ऑप्शन बी 7 years age. Section 82 of the Indian Penal Code establishes a rebutable presumptions of incapacity for children under 7 years of age, meaning they are generally not held criminally liable for the action. Question number 59. Dash is not a requirement of registration of a trademark. ठीक आंसर हेब ऑप्शन डी. The trademark should be well known. While a well known trademark has certain advantages, it is not mandatory requirement for registration. A lesser known or even completely new mark can be registered if it meets the other criteria. Question number 60. What is the punishment for copyright infringement? ठीक आंसर होची ऑप्शन सी. The Copyright Act 1957 prescribes varying punishments for copyright infringement, including imprisonment and fines, depending on the nature and severity of offence. The range you provided is generally accurate. Question number 61. Which of the following is not an intellectual property law? ठीक आंसर है ऑप्शन डी. Custom Act 1962. While the Custom Act can play a role in enforcing intellectual property rights by preventing the import of counterfeit goods, it is primarily a law related to customs duties and regulations, not a core IP law like Copyright Act, Trademark or Patents Act. Question number 62. Intellectual property rights (IPR) protect the use of information and ideas that are of ethical value, moral value, social value and commercial value. ठीक आंसर हेब ऑप्शन डी commercial value. IPR primarily focus on protecting intellectual creations that have commercial value, allowing creators to control and benefit from their innovations and expression in their marketplace. Question number 63. Doctrine of indoor management is an exception to principle of option B. The doctrine of indoor management established in the case of Royal British Bank versus Tirquand is exception to the principle of conservative notice. Conservative notice means that anyone dealing with a company is presumed to have read its public documents like the memorandum and articles of association. The doctrine of indoor management, however, states that the person dealing with the company is entitled assume that the company's internal procedures have been complied with, even if that is not actually the case. Question number 64. Where a director acts dishonestly to the interest of company, he will be held liable for option C. Option C. Direction have fiduciary duty to act in good faith and in the best interest of the company. If they act dishonestly, they can be held liable breaching this duty. Question number 65. Dash means prospectus issued by any financial institution or bank for one or more issue of the security specified in that document. Option A. Self prospectus allow to issue to file a single prospectus for multiple offerings of securities over a period of time, making the process more efficient. Question number 66. The judgment in the case of Force versus Herberton lays down the principle of option A. The rule states that the proper plaintiff in an action for a wrong done to a company, the company itself. It also emphasizes that the court will not interfere in the internal management of a company if the matter is one that can be resolved by a majority of shareholders. Question number 67. Dash lays down the modes in which of the object of company are to be carried out by the members. Option D. Articles of associations. The article of association contains the rules and regulations governing the internal management of a company, including how its objects are to be carried out. Question number 68. Estate is a term employed to denote lapsing of property to the dash in default of heirs on the death of the estate. यार ठीक आंसर है वो ऑप्शन बी गवर्नमेंट Estate is a common law doctrine where property reverts to state government if the owner dies without a will or without any legal heirs to inherit it. Question number 69. Which section of Copyright Act 1957 contains the powers of police to seize infringing copies? Option गुड़ाक देइछि सेक्शन 32, 64, 40 and 58. ठीक आंसर टी हेबो ऑप्शन 6 सेक्शन 64. Section 64 of the Copyright Act 1957 empowers the police to seize infringing copies of copyrighted works without warrant under certain circumstances. Question number 70. The heritage by property in which there are some privileges is called option D. C. Dominant heritage. In property law, a dominant heritage is a piece of land that benefits from easement or right over another piece of land known as the sovereign heritage. That dominant heritage enjoys certain privileges or rights over the sovereign heritage.